name is Sandrine Georges Skinner. I'm here as a member of the Journey of Hope from Violence to Healing. We are touring the state of Texas for 17 days to talk with Texans about the death penalty and the flaws in the system. My husband, Hank Skinner, has been on Texas death row for 15 and a half years. And obviously, I wanted to update you a little bit about what's going on with Hank's case at the moment, because if overseas the journalists have difficulty understanding the case, I can tell that also in the United States, I spoke to a journalist from Austin today, and they still say, well, when will you find out if the Supreme Court is going to grant your husband DNA testing? And I said, the Supreme Court, in the best of cases, is not going to grant Hank DNA testing. They will allow him to use the Civil Rights Act to pursue his lawsuits against the DA to apply for DNA testing and get the evidence tested. But that doesn't mean he would win that suit and that he will get the DNA testing. So we are far away.
How do most people get DNA testing though?
Well, the standard process is that you go through the habeas process, and which is part of the penal appeal system. But Texas enacted a law in 2001 called Chapter 64, which is for post-conviction DNA testing. But so far, only 3 people on death row have been granted DNA testing through the Chapter 64. And interestingly, the courts are telling Hank, you cannot hope or even imagine that you're entitled to DNA testing in your appeals because you did not ask for them at trial. And really, this is just ridiculous because the state is really contradicted its own laws. First of all, when Hank was tried, the Chapter 64 for post-conviction DNA did not exist. So there was no rule stating that he had to apply for them at trial, he couldn't apply for them at a later stage. And why would a state enact a law for post-conviction DNA if you were not entitled to it, if you had not applied for them at trial? I mean, that in itself is just nonsensical. It's ridiculous. You would not create a post-conviction DNA law if you assume that people will apply for them at trial or never have DNA testing. So the purpose of Chapter 64 was precisely for cases like Hank's case, where nothing was done right. And for those who may not know the details of his case, for his trial he was represented by an ex-prosecutor from that county who had to resign his position because he had embezzled drug money. He was a drug addict. And his ex-DA assistant became the DA, and they made a deal, say, you resign, you're not losing your law license, we'll give you some court appointments so you can continue to make a living. And beside the fact that he had prosecuted Hank twice on small offenses, which was already a major conflict of interest for him to be defending him, the guy was paid the highest ever paid fee in Texas to represent a capital defendant, and that amount matches almost to the dollar a huge IRS fine he had to pay, otherwise he was going straight to jail. So that man basically just sold him out. Didn't do the DNA testing. A number of witnesses that Hank had contacted his court-appointed attorney, gave affidavits. He never subpoenaed them, asked them to testify. He did not inform the defense expert on toxicology about major medical issues in Hank's case. I mean, the guy just didn't do anything. He let his client be convicted, and he was convicted solely on the basis of one witness for the state who was threatened, and she was really scared. She was threatened to be charged as an accomplice to capital murder, that her children would be taken away from her, that her 13-year-old daughter would be called to testify. But despite the risk of her being charged with perjury 2 years after the trial, she recanted her testimony. And she even came to testify in 2005 at the evidentiary hearing that took place in Amarillo. And when she came to testify, I will always remember. And she's very frail, very fragile. And she took the stand, she swore, and the judge reminded her. He said, Mrs. Reed, are you aware of the risk that you are taking? You can be charged with perjury. Would you like the assistance of a court-appointed attorney? And at that point she said yes. So she went and left the courtroom and got the assistance of a court-appointed attorney for several hours before she came to testify. but she clearly testified and explained how she was given a script to read for the police and at trial. And when she came to attend the trial, the police was guarding her motel room door and didn't let her move around until she had testified. After that, she was free to go.
Was this the neighbor whose house
Yes.
Hank went to?
Yes, absolutely.
After he discovered the
Yeah,
bomb?
but 2 years later, she realized that it was only her testimony that sentenced him to death. There was no physical evidence, there's no motive. And even the toxicology expert who testified, he heard her testify first, and he said, I could not reconcile my scientific findings and what this woman was saying about Hank's physical capabilities after the crime. It just didn't make any sense, but I sort of distanced myself a little bit from the scientific result and didn't want to push it too much. And that expert found out 2 years or 3 years after the trial that Hank was actually allergic to codeine, which he did not know to prepare his deposition or his affidavit. And this man was an FBI expert. It's the first time that he testified for the defense. And he said that from all the cases he's worked on in his life, this is the case that haunts him, because he knows that Hank is innocent. And he cannot understand to this day what, not only we are not getting the DNA testing, and everybody talks about the DNA testing in Hank's case, but that's just the tip of the iceberg. There are numerous issues in the case, and for me the primary one that makes the DNA quasi-irrelevant is his physical capability at the time of the crime. Beside the fact that he had ingested a drink, obviously from somebody else's glass. It was New Year's Eve, he picked up a glass, and somebody had medication in the glass, and the codeine and the combination of codeine and alcohol just knocked him close to being dead. All the medical experts who have worked the case have said he's lucky to be alive. He was in a coma. But he also had an important wound to his right hand, which was several months old, but got really badly infected and required surgery. So he had lost about 30% of flesh in that hand and 50% of strength in that right hand. And if you look at the autopsy report on Twyla's, the circumstances of her death, she was strangled by hands extremely strong with equal strength in both hands. So to me, those two things, whether we test the DNA or not, say exactly what we need to know. The police expert who testified at his trial about the blood spatter, because he had some blood stains on his clothes, clearly stated that there were contact stains, they were not splatter, that really it was inconsistent with him being the assailant. But for some reason the media keep misrepresenting that constantly. And there was a really tragically bad article by Michael Kravzik from the Associated Press on October 10th that was just reporting factually wrong information, lies. He has interviewed Hank a number of times. He has reviewed the case. It's not like he doesn't know the case. He knows.
I actually invited him tonight.
We do not know why to this day. I know Hank has written to him. I'm typing up the next hellhole news for Hank, and there's a substantial part about this. Why? Kravzik never really goes in depth when he reviews cases. He just summarizes things, but he's usually neutral. And on this particular occasion, he's not neutral at all. And when I read it, and Hank's daughter read it too, Natalie, and we emailed, and we just could not believe it. And I said to her, I said, you know what, I'm just gonna JPay Hank and send him a copy of this, but I need to do a paragraph before, because his BP is going to go through the roof. He's going to have a heart attack when he reads that.
What did Graysick say?
Well, he said, first of all, he started his article saying an ex-con, a car thief, a parole violator, which is both are false.